And we are back. Yes, Get Legit LLC. We're back, and today we will be having a discussion as it relates to this case. Has to do with a minor, Laddie Gillett, who was killed by a on-duty police officer. This is my disclaimer as it relates to this video, that if we're using any copyrighted materials, that any information here is solely for educational purposes only. For those of you who haven't yet subscribed to my channel, please like, comment, share, and do subscribe to the channel because I'm trying to grow. Now let's get into it. This young man, his name is Laddie Gillett. He was killed by a police officer after a BDF-trained security guard called the police because Laddie and a friend were walking on the beach near the Placencia Beach Club. That is my summary of this case. Okay, now let's get into the actual judgment. Before we do so, the decision came out last week, Friday. That was April 23rd, 2023. And both attorneys had a lot to say. We had the defense counsel, Mr. Oscar Salgado, gave an interview, and we had the attorney who basically shadowed the prosecution's case, who was there for the interest of the family, Mr. Richard Dickey Bradley. He also gave an interview. So let's get into what these two gentlemen had to say as it relates to the verdict.
This will definitely go to the appeals court and let the court of appeal give it what value they think. And I will raise the same argument that Claude Augustine had a firearm. He had two firearms out there. None of the firearms were sent to the examination, to the ballistic examiner for analysis. And Michael Miranda's firearm was not sent for analysis. How can the court be satisfied beyond a reasonable doubt that they had not fired their firearms simply because an extended shell from their firearm was not recovered? They could have recovered it themselves. It was all at night. And the only way you could remove that doubt is by going to the ballistic examiner, to the National Forensic Science Laboratory, and say, these weapons were not fired.
I listened carefully, and I want to say two things. One is that Justice Antoinette Moore is seldom disagreed with at the Court of Appeal. And the other one is that that judgment today, which went up until midday according to the court clock, that was so impeccable and covered every angle. And you all heard the testimony in the court. The testimony is just too strong. It is unlikely on appeal that a court of appeal could say that the justice.
Okay, Jay, you had it. Oscar Salgado putting forward his position that he intends to appeal, and Richard Dickey Bradley speaking as it relates to prospect of this case on appeal. So let's get into the judgment. A young teenage boy attempting to reach his residence by the 10 p.m. COVID curfew was shot dead on the Placencia Beach in July 2021. The accused, who was an on-duty policeman at the time, is charged with firing the fatal shot. The particulars of the indictment are that Kareem Martinez, on the 14th day of July 2021, at Placencia Village in the Stand Creek District, in the Southern District of the High Court, caused the death of Laddie Gillett by unlawful harm, to wit, by shooting him with a firearm. The accused pleaded not guilty to the crime when he was arraigned in the Southern District of the High Court on the 27th day of January 2023. The trial was conducted without a jury pursuant to the provisions of Section 65A of the Indictable Procedure Act as amended by Act Number 3 of 2022. The amendment to Section 65A provides for the trial of persons indicted for manslaughter and certain other offenses before a judge of the High Court sitting alone without a jury. The amending act came into force on the 22nd day of March 2022. This trial occurred after the Indictable Procedure Act amendment of 22nd March 2022. Thus, the accused was tried by a judge alone. The crime of manslaughter is defined at Section 116 of the Criminal Code as follows. Every person who causes the death of another person by any unlawful harm is guilty of manslaughter. Elements of the offense of manslaughter, 4 elements. In order to convict the accused of manslaughter, the Crown is required to prove the following elements so that I feel sure of each. 1, that Laddie Gillett is dead. 2, that he died of harm. 3, that the accused caused the harm that resulted in the death of Laddie Gillett. And 4, that when the accused caused the death of Laddie Gillett, he had no lawful justification to do so. Now let's get into the prosecution's case. A general overview of the case. In attempting to prove its case, the prosecution presented evidence from a total of 17 witnesses. Statements from 7 of these witnesses were read into trial record, eliminating the need for them to personally attend and testify. This agreed evidence came from Amy Fox, J. Gillett, Dr. Sarah Garcia, Martinez, Emil Bradley, J.P.'s Norman Leslie, and Glenford E. and Sergeant Lewis. The justices of the peace, Leslie and Sergeant Rodriguez, were of little assistance to the Crown or defense in this trial. Witnesses who gave viva voce evidence in trial were the scenes of crime technician Pablo May, eyewitnesses Thomas Palacio, Devin Castillo, a security guard, Special Constable, that's the SC, Special Constable Michael Miranda, Police Constable Isaiah Pop, and Police Constable Claude Augustine, Corporal Foreman Choco, Dr. Lyden Ken, Shirley Lino of the National Forensic Science Services Laboratory, and Sergeant Holly Vasquez. The case investigator also testified in the trial. PC Augustine was called at the request of the defense and was not initially questioned by the Crown. However, as events unfolded in the trial, PC Augustine was recalled, as was the expert witness. Miss Lino to testify. I'm making a mistake. Miss Lino to further assist the court. My apologies. The Crown's case in brief is that the accused, a police officer on duty with other officers, arrived at the Placencia Beach Club, encountered the deceased, and unlawfully shot him in his back as he fled. Laddie Gillett is dead. Now the judge is going into the different elements. So this is the first element she needs to satisfy. 1, that Laddie Gillett is dead. So to do so, at paragraph 13 of the judgment, it says, a statement from Dr. Sarah Martinez Garcia, a doctor at the Placencia Polyclinic, formed part of the Crown's case. She pronounced an unidentified young man dead at the clinic at 10:21 p.m. on the night of the 14th July 2021. The statement of Emil Bradley, guardian of the deceased, was read into the trial record. Mr. Bradley said in his statement that on the 19th of July 2021, he attended the Belize Medical College morgue and identified the body of Laddie Gillett to the doctor and the police officer present. The statement of Emil Bradley, guardian of the deceased, was read into the trial record. Mr. Bradley said in his statement that on the 19th July 2021, he attended the Belize Medical College morgue and identified the body of Laddie Gillett as to the doctor and the police officer present. I read the same thing over. According to Dr. Ken's finding, the body of Laddie Gillett had one entry wound to the left side of the upper back near the shoulder blade and one exit wound to the chest of the deceased. So it entered and exited. The wound entered from the left side of the upper back near the shoulder blade and exited to the chest of the deceased. Dr. Ken testified that the cause of death of Laddie Gillett was hypovolemic shock due to internal exsanguination due to a single perforating gunshot wound to the chest. And I read it again, a single perforating gunshot wound to the chest. He testified that the massive loss of blood inevitably led to death. And so the court said, based on the above evidence, I am sure that Laddie Gillett is dead and that he died as a result of harm as defined in the law. The accused caused the harm that resulted in the death of the deceased. Evidence of Michael Miranda, Isaiah Pop, Claude Augustine. So all these three gentlemen are police officers. There were 3 other police officers at the scene with the accused. They had accompanied him to the Placencia Beach Club to investigate, quote unquote, suspicious persons. Based on the report of the club's security guard, Devin Castillo, they each identified the accused in the court as Corporal Kareem Martinez, whom they had each worked with for a period of months, for a few months before this incident. Basically saying that the accused was positively identified by these officers by virtue of recognition. They haven't worked with him for a period of few months. Special Constable Michael Miranda performed poorly as a witness, but his testimony proved somewhat hopeful nonetheless. He was vague and in several responses said the exact opposite of what he had previously said to the same question. He said after the 4 police arrived, he searched the area with Mr. Castillo, the security guard. This differs from what the security guard said he did after the police arrived. However, after hearing all of the evidence, I, meaning the judge, I accept this aspect of Special Constable Miranda's testimony. Miranda said, as he and the other officers searched the area, he saw 2 persons coming from the bushes. In reply to questions about the bushes, he said, the 2 persons jumped a 6-foot fence and came from the bushes that were behind the fence. I found the idea incredulous, and this is a judge speaking. I found the idea incredulous, and even more so after visiting the scene and viewing a high fence in the immediate area. Thomas Palacio, who is one of the witnesses in this case, the person who was with Laddie Gillett when he was killed, Thomas Palacio said he did not jump the fence. Furthermore, he said there was a dog behind the fence, so he and the deceased, Laddie Gillett, would not have gone behind the fence. Miranda said he did not see the two persons jump the fence, which makes me wonder why Miranda told this fantastic tale. Miranda also testified that he heard someone say, quote unquote, "Stop." He claimed he could not say who gave this command, but he heard it as he saw the two persons begin to run away from him, his colleagues, and the security guard. And he was in possession of a firearm at the scene, but testified that he did not draw or discharge it. After assessing all the evidence, I accept that. Meaning the court accept that Miranda had a firearm at the scene. He drew the firearm. He said, he's saying here he did not draw the firearm, nor did he discharge it. So basically Miranda is saying, yeah, I had a firearm, I had a gun, but I never pulled it out and I never shoot at anyone or anywhere or in the air, whatever, okay? Miranda did not discharge his firearm at any point during the incident. However, by the close of the trial, I, meaning the judge, I believe Miranda did draw his weapon and pointed it at Thomas Palacios' head after Thomas fell to the ground when the deceased was shot. Miranda testified that during the incident, he heard a loud bang. One would think, as a special constable, he would distinguish a gunshot from another loud bang, especially when fired in relative proximity to the constable. Special Constable Miranda did not say who fired the one shot he heard, or even from which direction the sound came. I am sure he would have looked in the direction of the gunfire, if only for his own protection. Now, this is what the judge is saying. The judge is looking at this thing and what would a reasonable person do? And she's saying, even if for his own protection, she believes he would have looked to see who is shooting and where it came from. But Miranda is saying he didn't see. He only heard stop and then heard a bang. Remember, he did not say he heard a gunshot. He heard a bang. And anything could make bang. It could be a tire burst. It could be a firecracker burst, but he's saying he heard a bang. And the judge is making the distinction that these are not just regular folks. These are police officers, okay? Continue reading. He testified he saw nothing in the hands of either persons as they ran. He also said he saw no scuffle between either of the persons who ran and any of the police or the security officer. This pivotal testimony was confirmed by each Crown eyewitness. I believe it to be true. I believe it is true that there was no scuffle and that neither Thomas nor Laddie had anything in their hands. This is what the judge is saying she believed. That evening, Special Constable Miranda said he was wearing black pants and a white polo shirt that had an emblem on the front. The witness, Thomas Palacios, said the men who approached him and the deceased wore black clothing. He did not recognize them as police, and they did not identify themselves as police. Now the judge is saying, I believe this included Special Constable Miranda and Devin Castillo, the security officer, who are apparently wearing all black. So here you have the judge saying she believed that they were wearing all black. So she believed what Thomas Palacio is saying, as opposed to what Miranda is saying, that he had on white polo and black bottom. Continue reading. Police Constable Isaiah Pop, who at the time had been a police officer for a little over 2 years, initially testified that he and the other officers arrived at the beach club at about 10:30 p.m. When I explained that the doctor at 10:21 p.m., he arrived earlier than 10:30 that evening. You think? Police Constable Pop said he was not in the scuffle with either of the two individuals they encountered that evening, nor did he see any of the police officer in a scuffle with either of the two persons. I believe him when he said he did not carry a firearm that evening. He further testified that he was not afraid during the incident. He heard someone say, quote unquote, "Stop." But just like Special Constable Miranda, he could not say who uttered the word. He too heard one shot and also did not say who fired their gun. He confirmed certain key aspects of the evidence, but overall was less than helpful about the events of that night. Part of his testimony follows. Now I'm going to read what is in the judgment, part of his testimony. And this is what he's saying, quote unquote. He said, open quotes, "We saw two individuals running whilst pursuing them. Yes, I personally, when the two persons from Corporal Martinez, PC Augustine, and SC Miranda were with me. I am not sure if the security guard was there or not. Yes, the four of us were together in one group. I am not sure which direction they were running, but they were headed towards an open area. I heard someone say, 'Stop!' I don't know who gave the command. I heard a loud bang. Immediately upon hearing the loud bang, at the time I heard the bang, I went towards one of the individuals. I do not know where the loud bang I heard came from. It sounded like a gunshot." PC Pop's evidence was qualitatively better than that of Special Constable Miranda. However, aspects of his testimony raised some doubts in my mind about his truthfulness. For example, a trained police officer who has had firearm training should be familiar with the sound of a gunshot. Yeah, I would think so too. I expect civilians to say they heard a loud bang, not a police officer. Moreover, PC Pop said he could not tell from which direction the sound came. I also found this difficult to accept. Nonetheless, the general story PC Pop told is consistent with the other police witnesses. I was left with the inescapable impression that each of the officers who testified for the Crown were attempting to distance themselves from the possible wrongdoing, trying to implicate the accused as little as possible, and attempting to conceal their general conduct at the scene, which was less than exemplary. They were each incorrect about the time they arrived at the beach club and consequently gave erroneous testimony as to the time of the incident. This was significant because the officer said they detained Thomas Palacio and conceivably would have detained the deceased also for a curfew violation. Even though the officers who were Crown witnesses said this, the accused said Thomas was detained for aggravated assault of a police officer. There is no plausible evidence that a police officer was assaulted at any time, or that any one of the officers or Mr. Castillo was under any threat or danger. And each officer spoke about being rushed by the individuals who jumped from the bushes. But when visiting the scene, the bushes in the area were low. And based on the evidence, I do not believe the deceased jumped from any bushes. Thomas Palacio said they were jogging on the walkway. And as soon as they saw the men, the deceased and he ran away from them in fear. They did not rush towards the men, neither violently nor aggressively. Had the deceased and Palacio rushed towards these police, I believe the police would have grabbed one or both of the young men, considering how small the area was in which the encounter occurred. The evidence supports Thomas Palacio's version of events. Neither Miranda, Pop, nor the court with who fired the weapon that evening, except for each to say that they did not discharge a firearm at the scene. The security guard also testified that he did not possess a firearm that evening. If I believe these witnesses, by a process of elimination, there is only one remaining person who could have fired his firearm, killing the deceased. That is the accused. The accused admits in the station interview and in court that he fired his firearm one time. Although he does not admit to shooting the deceased, I will examine the defense submission on this important issue below. Evidence of Corporal Fermin Choco. The testimony of Corporal Fermin Choco assisted me in understanding the events surrounding the incident. After being alerted of the shooting by his superior, he went to the scene with the scenes of crime technician and the accused, who was not detained at that time. Later, Corporal Choco confiscated a firearm from the accused and placed it along with his magazine and ammunition in a gun box, which he sealed and labeled. The corporal told the court that the weapon bore serial number G50009 and was a Bersa brand 9mm pistol. Corporal Choco ultimately took the gun box and its contents to the National Forensic Science Services laboratory for analysis. These items, the box, the firearm, the magazine, the ammunition, are exhibits in the trial. The expended casing, which was a 9mm Aguila brand found by Corporal and the scenes of crime technician, is also an exhibit tendered by technician Mr. Pablo Mine. Corporal Choco drew a sketch at the scene. This sketch was admitted into evidence in trial and became more useful during the visit to the locus. In the investigation, Corporal Choco also interviewed a number of witnesses, including Amy Fox and Jade Gillett. The expert evidence of Shirley Lino. Now let's get into it. Miss Shirley Lino would have been the expert dealing with this firearm. Shirley Lino, a firearms examiner from the National Forensic Science Services Laboratory, NFSS, testified about her analysis and conclusion regarding the exhibits submitted to the lab in this case. Ms. Lino has a master's degree in forensics and has worked at the NFSS for 13 years. She said her work at the lab was as a firearms examiner, which includes the analysis and classification of firearms, ammunition, bullets, and cartridge cases. I recognize Ms. Lino as an expert in the area of firearm examination, and bear in mind that she was deemed an expert as a firearms examiner. Okay? Ms. Lino testified that based on her testing and the Bersa brand pistol with serial number G50009, exhibit FC1A, was capable of firing and the pressure needed to apply were within normal limits for such a firearm, meaning the firearm was working. She further concluded that the submitted expended cartridge case, the Aguilar brand 9mm caliber, was fired by the Bersa pistol, brand pistol with serial number G50009. So what she's saying there is that the cartridge case came out of that gun that Choko said he got from the accused. She explained that she concluded this by firing the pistol using the ammunition submitted and comparing these expended shells to the expended cases from the scene. On cross-examination, Ms. Lino agreed that with learned defense counsel, this is Mr. Oscar Salgado, that the NFSS lab is not accredited. She also agreed that findings in firearms analysis and comparison may be subjective. Although she qualified this statement by saying that aspects of firearm analysis are subjective, but the lab requires that multiple samples be used in comparison testing. Additionally, she noted that to counter possible subjectivity in testing, the NFSS has protocols in place, including peer review since 2016. In peer review, another analyst examines the same items to test the outcomes. She said that in this case, peer review of her conclusion was carried out. Ms. Lino also agreed that she could not say unquestionably that the Bersa pistol fired the shot, but only examining the recovered casing. But when asked by me, this is a judge, Ms. Lino added that she could confidently say that it was this firearm that discharged the ammunition that left the casing. Her findings, she testified, were based on the abundance of general characteristics as well as the individual characteristics which I observed under the microscope. Once it became clear that the defense case was that the accused had discharged his firearm but had not shot the deceased, I recalled Ms. Lino to seek further assistance from her. When asked about her ability to assist regarding trajectory of bullets, she said she was only able to speak to the trajectory of bullets in a limited capacity. Please note that. So you have the firearms examiner, the expert, deemed an expert by the court. She was recalled by the judge, and the judge asked her further questions as it relates to whether or not she can give assistance when it comes to trajectory of bullets. And her response is, she said she was able only to speak to the trajectory of bullets in a limited capacity, having received some crime scene construction training that included the trajectory of fired bullets. Ms. Lino said it was possible that a bullet fired into the air could hit someone in the back as they stood. I asked these questions after the defense theory was clear that the accused fired his weapon in the air, but that his bullet was not the fatal shot that struck the deceased in the back. Ms. Lino said, if a gun is pointed upward and fired in the air, the bullet can travel several feet up, but may be affected by gravity. Remember, gravity, what goes up must come down, okay? After a certain point, the gravity would cause the bullet to fall back to the earth. The factors affecting it could be the position of the person who was, the position the person was firing the firearm, and several environmental factors or climate differences, which would affect the trajectory, for instance, the wind. Studies have shown that a bullet that traveled back downwards after being fired in the air has a higher possibility of striking someone on the upper part of the body. There is also a chance for the lower portion of the body to be hit as well. I can't speak to the angles, but that would be a possibility for the bullet to hit someone in the back region. That is why they discourage shooters to fire firearms during times of celebration, such as New Year's. And then some specific question was asked to her by Learned Senior Crown Counsel. And the questions are these. Could you say how many inches does a slug fired from a 9mm drop at 100 feet? Is it true that for every 100 yards or every distance a bullet starts falling down? And this is her response. The longer the distance the bullet travels, there may be some decrease in height of the bullet when it is traveling in the air. Next question. Can you say if the bullet fired in the air from a 9mm gun, is it possible to hit someone at 100 feet away? Her response. It could be possible. I would say it is possible. We would have to look at the environmental factors, the wind, the angle of the shooter. It is hard to say. It is not possible. I cannot say for the distance. Another question was asked. If I have a 10-foot pole in front of me and I am pointing 10 feet high up, is it possible to hit someone 90 feet away? Her response, a 9mm bullet can travel up to 1,000 feet. And next question. The target is 90 feet away from me and I am firing in the air. Can that bullet hit the back of the person? And her response, I can say at 90 feet, the bullet has a lot of kinetic energy behind it still. And 90 feet seems to be a short distance to where a bullet fired in the air would have enough energy to fall at 90 feet. She continued, it has so much power or kinetic energy behind the bullet still to allow it to fall from a great height at 90 feet. It is unlikely, but it would fall that distance in the space of 90 feet. In responding to the Learned Defense Counsel, Ms. Lena said it was possible that two guns shot at the same time could sound like one explosion, but she added that she could not give the likelihood of this happening. This related directly to the defense theory that there were two shooters, even though everyone on the scene heard one shot. So basically what the defense theory is, two persons had gone on the scene. Remember, Miranda had his firearm, but the court accepted that he never drew it, took it out. The court accepted that while he drew his firearm, he only did so after the deceased was on the ground, and he did so to put it at Thomas Palacios' head. The court accepted and believed that he never fired his firearm, even though what the defense is saying in his interview that there wasn't any evidence to say to test that firearm. There wasn't any. The only thing was done to test Miranda's firearm to show the court that it was not fired. So that's what the defense is saying, is arguing in his statement. Here we have it, two firearm, Miranda firearm, the accuser firearm. The accuser already said he shot, but he's saying he shot in the air. He did so in an interview, all right? And he did so in court. But you have Miranda. Miranda is saying, Miranda evidence is that he never took it out his firearm. He had it on him, but he never drew it. And he's also saying that he never shot the firearm. And the court is saying, well, I accept you had your firearm, but I don't accept that you didn't draw your firearm. The court, you didn't draw your firearm. The court accept that he drew the firearm, but he only drew it to put it at the Thomas Palacios' head. That is what the court accepts. That's the evidence the court accepts, okay? So now I'm going to get into, I missed where I was. Okay, paragraph 33. The judge is saying, no, I also consider Dr. Kent's testimony that in this case, the characteristic of the gunshot wound, The entry of the gunshot wound is that of a distant range wound. A distant range wound, he said, is classified as more than 2 feet or 18 to 24 inches between the shooter and the target. During the locust visit, the distance between where the casing was recovered and where the deceased fell after being shot was about 75 feet. The scenes of crime technician had testified the distance between the collecting casing and the blood spot was 25 yards, and in brackets 75 feet. This distance qualifies as a distant range. This information aids me, this is what the judge is saying, aids me in envisioning the scene on that evening when the bullet was fired. The only bullet there is any evidence about in this trial. So basically what the court is saying is that one shot, one casing, one impact, one entry in the back, shoulder blade, and exit in the chest. One. So the doctor is saying one. The doctor also testified as it relates to shot. It looked like he was shot from a distance. So that's what the court is looking at there. Paragraph 35 says, here, I have no reason to reject Ms. Leno's findings that the empty shell casing found at the scene is consistent with other shell casings from tests firing the accused weapon. The witness's evidence was of such a quality as to leave me without a doubt that the firearm assigned to the accused by the department was discharged at the scene. In addition to the helpful evidence by Ms. Leno, I accept the combined evidence of the witness, Special Constable Miranda, Police Constable Pop, Police Constable Augustine, and Security Guard Devin Castillo, with respect to them hearing only one shot and none of them discharging a firearm. It is also of note that no other casing was found at the scene by the crime scene technician. So now the court is looking at Claude Augustine's testimony. Claude Augustine, remember this is a police officer too, testified at trial at the request of the defense. So that means Claude Augustine was called by the defense. He first testified, well, that means the defense requested that Claude Augustine be called before the court. He testified that he had no firearm. He first testified he had no firearm at the scene, and neither did he discharge a firearm during the incident. The learned defense lawyer uncovered that this witness told the police tribunal that, in fact, he had signed a firearm on the day of the incident. When recalled as a witness, Augustine ultimately admitted that he did have a firearm with him during the incident. He claimed the firearm he carried with him was his personal weapon. He was then confronted with the fact that he had signed out a department firearm. He denied that the logbook had his signature signing out the weapon. He denied taking a police issue weapon to the scene. PC Augustine told a fantastical story of signing out a firearm but leaving it at the station in a safe whose key is left at the front desk of the Placencia police station with no one controlling it. PC Irene Augustine testified in trial and said that no firearm was signed into the safe by PC Augustine on the 14th July 2021. As to the incident at the scene, in cross-examination by the defense counsel, PC Augustine said he had not heard anyone at the scene say, "Police, stop." And he did not recall saying this in his statement. Once shown his police statement, however, he recalled saying this. When I examined the witness's testimony, I don't think he had poor recollection. He was purposefully dishonest to the court. I think he was afraid of the very thing that his dishonesty prompted, that he would be accused of shooting their deceased because he had a firearm at the scene. The defense submitted that because the accused another person of the scene, besides the accused, another person on the scene fired his weapon during the incident, and it was that person who actually shot the deceased. I consider the submission that someone other than the accused fired the fatal shot, or any shooter at all. The defense submission is that PC Claude Augustine was directly behind the deceased, and it was Augustine who shot the deceased. The Lorraine Council theorized that PC Augustine fired his gun at the same time, here it is now, at the same time that the accused fired a warning shot in the air, making a sound of one explosion so that those present would not have been able to recognize that two shots had been fired by two different people. The Lorraine Council submitted further that Augustine retrieved the casing from his weapon in the dark and was not seen doing so. The theory, however, is not supported by any evidence. There were no strands of evidence from which I could draw the inference that Augustine shot the deceased. I would have to speculate to accept this scenario, and I cannot do that. By the end of the trial, it was indisputable that PC Augustine carried at least one firearm to the scene. It was also pellucid that he had not been honest in his testimony about being in possession of a firearm at the scene. These facts, however, do not lead me to conclude that he fired his gun that evening on the beach or that he shot the deceased. I do not believe that PC Augustine fired his weapon at the scene. By all descriptions of the events, Augustine was physically closer than the accused to the other witnesses, including Thomas Palacio. Had PC Augustine fired his gun, I believe someone would have seen it. The sound would have been closer to all of them. I simply do not believe that PC Augustine drew and fired his 9mm, and Miranda, Pop, Castillo, Palacio, and even the accused, who was behind all of them, did not observe it. Now, the court went into the testimony of Holly Vasquez. Sergeant Holly Vasquez, who was posted at the crimes investigation branch in Dangriga, was of report. After the shooting, he was ordered to help investigate, and he traveled to Placencia to conduct interviews. In interviewed Thomas Palacio and Devin Castillo and 3 police officers, Special Constable Miranda, PC Pop, and the accused. In the station interview of the accused, Sergeant Vasquez asked him 58 questions, all of which were recorded on a cellular phone video and transcribed. Below, I have reproduced the most relevant questions and replies. I will return to discuss this importance later in the judgment. The following is a portion of the station interview conducted by Sergeant Vasquez, which now forms part of the trial record. So these are the questions Sergeant Vasquez asked the accused, Akeem Martinez. Upon the arrival at the Placencia Beach Club, what, if anything, happened? And he said, upon arriving, we noticed the area was very dark. Made checks around the area for security and found one Mr. Castillo, known to me as Danger. Mr. Castillo then gave us a brief synopsis of what happened, and that there were 5 male persons hiding near the beach and near a wooden fence. All 4 police officers accompanied by Castillo went to make checks. However, nothing was found. Next question. Can you say about what time this was? And he said, 9:58. Next question. Would that be 9:58 in the night or morning? 9:58 in the night. Next question. After the search was done and nothing found, did you do anything further? Response. We combed the beach side, and whilst walking along the wooden fence, while reaching the end of the fence near the open, 2 male persons rushed into us. I then noticed a struggle ensued between PC Pop and a male individual. We then identify ourselves as police to get the individual to stop. However, they continued. A single gunshot was burst into the air, and shortly after, one of the individuals stated he got shot. The other individual had already been subdued. We removed the individual and immediately rushed him to the Placencia Beach. Next question. You said you saw a struggle PC pop, and elaborate exactly what you saw? I don't have the response to that. I need to go back in judgment. Anyway, let me continue to this question. You said that we identify ourselves as police. At what point was this done? At about 10 seconds after the individuals rushed towards us. Next question. From your vantage point, did you saw any weapon by any of the individuals? His response, I believe they had something in their hands, a shining object, but could not see clearly. Next question. You said a single gunshot was fired towards the air. By whom? And the accused response, myself. The next question. Was the shot fired in the air towards the direction the individual ran? He said no. Next question. How long after you burst the shot in the air that you heard the individual stated he got shot? He said about 6 seconds after. When the shot was fired to the air, what became of the other individual? He said the other individual immediately went down. You said you removed the individual and immediately rushed him to the polyclinic. Which one of the individual? The one that stated he got shot. So what become of the second individual? He was also taken to the mobile and brought to the Placencia police station and handed over to PCI Augustine, that's Irene Augustine. Was the individual informed the reason why he was detained? He said, yes. Could you say for what? He said, aggravated assault upon a police officer. Could you say which police officer assaulted? PC Pop and PC Augustine. Now the court went to the locus. That means the scene where this incident took place. Okay, I'm not going to read that, but the court visited the locus. Now, conclusion of the third element. Remember, the different elements the court is going through. When I combine the evidence of the 3 police constables present at the scene of the time of the shooting, along with the experts' ballistic evidence, the station interview of the accused, and the locus visit, I have no doubt that the accused shot the deceased, resulting in his death. No, so the last element the court is looking at, no, the accused killed the deceased without lawful justification to do so. Since I am sure that the accused shot the deceased, causing his death, I now turn my attention to whether the accused was lawfully justified in doing so. To determine this, I must carefully consider all the circumstances surrounding the incident. That is, what happened before, during, and after the shooting. If the accused was lawfully justified in killing the deceased, the Crown would not have met its burden in respect of the crime of manslaughter. I first look at the statutory law on justification. So the court went into the law as it relates to justification. And then now we go into the testimony. Thomas Palazzo was a thoroughly credible witness. He was vigorously cross-examined by the law and defense counsel and did not budge from his evidence. As with any press witness, he was not flawless and had memory deficits at points, which he admitted. For example, he said he did not remember the deceased wearing a face mask other than in the village. A bloodied face mask was collected at the scene, which I accept was worn by the deceased when he was shot. From the evidence of Dr. Thomas was also incorrect that the men he and the deceased encountered were wearing all black. The doctor said 2 of the police who brought the body of the deceased into the clinic had on white t-shirt and black pants. Mr. Castillo had described a couple of the officers wearing white t-shirt as well as they arrived on the scene. Mr. Castillo himself wore all black. These errors, in fact, made by Thomas are mainly immaterial. By the end of the trial, I was convinced that Thomas Palazzo had been truthful in his testimony. The story told by Thomas Palazzo was disturbing on many levels. Obviously, the most serious aspect of his testimony and the reason for the trial was his recounting of the shooting of his friend. But there were other aspects of his testimony that bring police conduct into disrepute. He described one of the men kicking him while he lay on the ground. After all of the evidence was heard, I am convinced the person who kicked Thomas was a security guard. Mr. Castillo kicked Thomas in the presence of the police officers. One of the police held a gun to Thomas's head. The police handcuffed, detained, locked him up overnight without providing him with a reason. If true, and I do accept this evidence, the witness was threatened, physically assaulted, and unlawfully detained by the police. This behavior by law enforcement and civilian in their company was inexcusable and potentially criminal. I don't think any of them were charged, but I could be wrong. And then now the court looked at the evidence from Devin Castillo. This is a security guard. I have highlighted some of his because I find him very troubling, and the court did so too. The evidence of the witness was crucial. He calls the police, his call to the police began the chain of events which led to the tragic outcome. He testified that he was a security officer working at 6 p.m. to 6 a.m. shift at the Placencia Beach Club. He saw 3 individuals, 2 males and 1 female, but says he could not distinguish their ages or if they were holding anything. He testified that the individuals were 20 feet away and then as close as 8 to 10 feet from him, close enough for him to distinguish their genders, but he says he could not detect that they were young persons. He testified that they were suspicious, but other than saying they appeared to be looking for something, he did not clarify why he assessed these persons as suspicious. He did not explain why persons appearing to look for something on the beach were suspicious. He called the police, but no one arrived. He called the police a second time, and they arrived a half an hour later. By then, as I understood, Mr. Castillo, the persons he thought were suspicious had gone on the path in a direction away from the clubhouse. He showed the police the direction they went in and left the area to continue his duties. Shortly afterwards, he heard a gunshot. It was established that Mr. Castillo had served in the BELIZE Defense Force and was familiar with the sound of firearms. He did not have a firearm in his possession that evening. I accept that he was not armed on the fatal night. The Placencia Beach Club was closed at the time of the incident. I asked the security officer, did he call the police every time persons approached the clubhouse after dark, since his conduct in this instance seemed to me a gross overreaction? On cross-examination, Mr. Castillo said he felt endangered by the presence of these 3 persons. Did he feel endangered by every person walking along the beach near the club? Mr. Castillo's answers were unsatisfactory in my view, especially when I asked some basic questions about how someone would know they were on the clubhouse's compound when still walking on the sand. When the court visited the scene, I was able to see the deck that Mr. Castillo said the 3 persons walked on. I accept this part of his evidence, especially since Amy Fox's statement said Thomas and Laddie had walked close to the club. Also, at the scene, I was able to learn that the club is 56 feet from the sea. As mentioned previously, the evidence of both Thomas and Amy is that they did not hear or see a security officer. Based on where Mr. Castillo told the court he stood near an outdoor shower, he was out of sight and would not have been seen by Thomas, Laddie, or Amy, who were merely walking by. While I believe parts of Mr. Castillo's evidence, I do not believe all that Mr. Castillo described. For example, he testified that he went on his duties when the police arrived, and he did not accompany them. I do not accept this. Mr. Castillo, like the police witnesses, was trying to create distance between himself and the shooting. I believe he was with the police when they encountered and chased the deceased and Thomas Palacio. I found much of Mr. Castillo's conduct inexplicable, and ultimately it proved dangerous. In this case, what was the reasonable suspicion that the deceased either had committed or was about to commit a criminal offense? According to Thomas Palacio, at the time of the encounter, he and the deceased were trotting towards the beach to return to Kabil Mar Resort. Mr. Castillo had not said he was afraid the people he saw were going to break into the club or try to steal anything. It doesn't, my apologies. It doesn't appear from the evidence that he said this to those who arrived at the scene. There is a defense submission that the deceased and Thomas had cellular phones in their hands because 2 phones belonging to the deceased and Thomas were found on the beach and returned to Thomas and the family of the deceased. The defense is saying that the accused could have reasonably thought the phones were weapons. The deceased and Thomas may have been holding their phones, but it is unlikely that the two continued to hold on to their phones as they ran. Mr. Castillo, according to the police dispatcher, said one of the persons have a firearm. He didn't when he testified. In his testimony, Mr. Castillo said he could not tell if any of the 3 held anything in their hands. Thomas Palacio said he did not have anything in his hands, and he saw that Laddie did not have anything in his hands. PC Pop said he saw nothing in the hands of the persons they chased. The accused said in his station interview that he believed they had something in their hands, a shiny object, but he could not see clearly. In his unsworn statement, the accused said in reference to the person that engaged in, quote, open quotes, a slight scuffle, close quotes, with PC Pop, open quotes, I saw a shiny object in the hand of this person, close quotes. The accused is trying to straddle the fence on this issue. I believe he is being purposefully vague on this important point. Ultimately, I do not believe the accused when he says he saw a shiny object in their hands or in the hand of this person. The accused had come almost face to face with Thomas and the deceased, albeit briefly, and would have then had a clear view if either held something in his hands. The police are not entitled to stop persons merely because they or someone else think the person are suspicious. The law says the suspicion must be objectively reasonable. This means the suspicion must be based upon something that is rational. Important related to this were pronounced by Justice James in consolidated cases of Nunes and Codd. I did not put the statement from the judge as it relates to what was in the judgment. I just went to paragraph 62. In this case, the judge was speaking about the Misuse of Drugs Act and the Firearms Act. These laws must conform to the Constitution. The Constitution, our supreme law, prohibits the police from stopping anyone, anytime, anywhere, for any reason. In the case before me, I have heard no objectively rational reason why the police attempted to stop the deceased. I can say, similar to the judge in the Nunes and Codd case, that the evidence here does not disclose reasonable suspicion that a crime had been committed or was about to be committed. Thus, The attempt to stop and detain the deceased was not, in my view, a lawful one. When Sergeant Vasquez testified, he said that what constitutes suspicious behavior will differ from officer to officer. Different police will assess the situation based on what they perceive, but that amounts to a subjective perception, not the standard set out in the Constitution. Sergeant Vasquez agreed that a police should not person on general suspicion only. If the accused did not have reasonable suspicion and therefore no lawful authority to detain, there would be no authority to pursue them. Furthermore, even if there was authority to pursue the deceased, the accused had no authority to shoot him. The Belize Police Department Policies and Procedures Manual, the manual, says in reference to fleeing persons, deadly force may not be used on a fleeing person unless the subject poses an imminent threat as defined above. Use of force. The manual says that the use of force is allowed if it is a use of force objectively reasonable, necessary, and proportional. Department members may only use force that is objectively reasonable, necessary, and proportional. In order to ensure the safety of a member or third person, stop an attack, make an arrest, control a subject, or prevent escape. In the leading case in Canada on the use of excessive force by police officers in R and Nassau Lock, the court said, but police officers do not have an unlimited power to inflict harm on a person in the course of their duties, while at times the police may have to arrest the force in order to complete an arrest or prevent an offender from escaping police custody. The allowable degree of force to be used remains constrained by the principles of proportionality, necessity, and reasonableness. Courts must guard against the illegitimate use of power by police against members of our society, given its grave consequences. There is no evidence in this case that the deceased posed an imminent threat to anyone. Moreover, the accused did not act proportionate to the circumstances, nor did he act out of necessity or in a reasonable manner. Indeed, the evidence is to the contrary. None of the police witnesses say there was any physical contact with the deceased. Thomas Palazzo testified that he was struck in his back by a hard object, but he did not turn and engage the person. None of the police witnesses said they felt in any danger. The security guard said before the police arrived, he felt endangered, although this was completely unreasonable in my estimation. If indeed Mr. Castillo truly felt endangered, I do not believe he continued to experience fear once 4 police arrived on the scene. All of the evidence leads me to conclude that the accused conduct was, in the circumstances, clearly disproportionate, unnecessary, and unreasonable, and ultimately resulted in irreparable harm. Discharging firearm, a warning shot. The accused claims that he fired a warning shot during the incident. I do not believe this to be true, and I will discuss why in the defense portion of this judgment. For the moment, however, I look at what the department says about warning shots. The manual says that the use of firearms are prohibited in certain prescribed circumstances, including firing warning shots unless it can be used as a means of de-escalating a situation or prevents the escape of a person being detained. Where this is the case, the warning shot must be fired in the air. Applying Section 30 of the Criminal Code to the facts of this case, there is no self-defense or defense of others claim. There was no provocation from the deceased. The code sets out the crimes that one would be justifiably defending against, including murder, manslaughter, burglary, robbery, arson, and other serious crimes. At this stage in my deliberations, the idea that there was a physical altercation or that either the deceased or Thomas assaulted any of the police or the security guard has been fully disproven. The accused was not executing a lawful sentence or order of a court, nor was he keeping the peace and preserving order when he shot the deceased. The accused was not reasonably attempting to arrest or detain the deceased for a felony or other offense. The accused's actions were not necessary to prevent or in defense against crime, nor necessary for the defense of property or possession. The code says that harm is justified to remove or exclude a person from any place or in self-defense and defense of others, but the harm used should not extend to a blow, wound, or grievous harm. Conclusions on the final element of manslaughter. In contemplating the element of unlawful harm, I conclude that the evidence of all the Crown witnesses, even those who were not wholly truthful, supports that there was no lawful justification for killing the deceased. I have no doubt whatsoever that the accused was unjustified in shooting the deceased. Good character. So in this case, the court looked at good character because he was a police officer. And even though there wasn't any thing coming out from the defense as it relates to good character, nor from the prosecution, the court went ahead and gave itself a good character direction as it relates to, not because the credibility, but as it relates to the propensity. So at paragraph 73, it says, after considering the good character of the accused and taking the propensity limit into account, it does not change my acceptance of the Crown's evidence that the accused committed the crime he is accused of on the indictment. I have reached this conclusion after considering that the conduct by the accused apparently would have been out of character for him, a person who had not previously been convicted of violating the law. Since I believe the Crown evidence, I can give the good character of the accused little to no weight in deciding the verdict. So now let's go to the defense's case. At the close of the prosecution case, I explained to the accused the three options available to him: to remain silent, to provide an unsworn statement, or to testify under oath, based on his rights as an accused person in a criminal trial in Belize. I also explained how the court is required to treat each of these rights. I asked the accused if he understood, and he said that he did. The accused chose to provide an unsworn statement. The defense called one witness, Police Constable Irene Augustine. So now I'm going to read from the judgment the unsworn statement that was given by the accused, PC Karim Martinez. My name is Karim Martinez. In respect to the matter beforehand, I must start by saying on 14th of July 2021, I was a corporal of police attached to the Placencia Police Station. Shortly after 9:45 p.m., whilst at Maya Beach Precinct, I received information of suspected persons on the beach at Placencia Beach Club, and we were informed I was informed that one of the individuals had what appeared to be a firearm. At this point in time, I recollected an event from the previous night where myself and Claude Augustine checked into a report by a man named James Leslie, who also stated to us that criminals known to him was outside his house and asked him to come out, which he said he refused. However, they stated that they will return because they believe he was in possession of drugs, namely cocaine, from a previous plane landing. Fearing that this would be the same individuals, I removed the Maya Beach Vehicle Patrol. I instructed them to accompany me to the Placencia Beach Club. Whilst on our way to Placencia Beach Club, we received another call from a diarist at the Placencia Police Station, namely PC Irene Augustine, who stated that the security had called again requesting assistance. Shortly after, we arrived at Placencia Beach Club, where whilst there, we met Devin Castillo, also known to me as Danger, who explained to us that there were a group of persons on the beach attempting to enter the deck at the Placencia Beach Club. However, the dog barked at them. He then stated to them, "Where uno da do here? This the private property." I asked if any of the males were in possession of a firearm, and he said he believed so. He then showed us the direction that the male persons went, and we then proceeded to the area that led us to the area beside the Placencia Beach Club, close to the beach. That would be myself, PC Augustine, PC Pop, Special Constable Miranda, and the security officer. We searched along the fence and the beach side and found nothing unusual. We then turned around to proceed back to the Placencia Beach Club. Whilst approaching the end of the fence, the wooden fence, two male persons came running towards us aggressively. Upon noticing us, the male persons then pushed back, where they was immediately followed by the security guard and Special Constable Miranda behind the first individual, and PC Augustine and PC Pop behind the other. Whilst running, I remained on the beach, standing and walking to try and see what exactly was happening. I noticed PC Pop and one of the individuals got into a slight scuffle. I saw a shiny object in the hand of this person. I then turned around from the individuals that were running, removed my police-issued firearm, and fired a shot into the air. Then that would be 10 feet off the ground into the air. Shortly, I remained on the beach. Shortly after, I was called by PC Pop, who stated, "Corporal," a short thing for corporal, "come here." I then made my way over to PC Pop, who was standing about 90 feet away from me from where I was. Upon reaching to where PC Pop was, he was on his knees and he had an individual in his hands. I then asked him if the male person he was holding was hurt, and he said he didn't know. I asked him to check. Whilst doing so, I went over to the other group where another male person was on the ground also. And PC Miranda, I believe that's SC Miranda, and security were around him. I removed the person and asked Special Constable Miranda to escort him to the mobile, and I also asked PC Augustine to get the mobile. Both male persons we then was placed in the mobile. One was transported to the Placencia police station. Whilst on the way, we called the diarist to inform her that we had an injured person on board the police mobile. Whilst on our way to call the diarist to inform her that we had an injured person, on board the police vehicle to contact the polyclinic, which she did, the other male person was transported to the Placencia Polyclinic, where shortly after arrival at the Placencia Polyclinic, he was pronounced dead by a doctor at that location. I then returned to Placencia Police Station to wait for OC of Placencia Police Station. The OC arrived and also Corporal Fermin Choco, where Corporal Choco asked me to accompany him to the scene of the incident. We then proceeded to Placencia Beach Club, myself, PC Choco, and PC Cub. Upon arrival, we also met the security again, who was in possession of 2 cell phones that he said he recovered from the scene. He stated to me that he wanted to hand the cell phones over to me. However, I informed him that Corporal Choco is the person in charge at the moment, and he should hand over both phones to Corporal Choco, which he did. We then made our way around the scene, and shortly after, Corporal Choco asked me to leave and return to the station to write a report, which I did. That is all, my lady. So that is the end of the unsworn statement given by Kareem Martinez. I keep saying Akeem, but it's Kareem Martinez. So the court did the assessment of the statement by the accused. So this is what the court said. As I dissect and consider the statement of the accused, I have concluded that I can give it some weight and therefore accept portions of it. However, I cannot give the statement a great deal of weight. I reach this conclusion in part because I do not believe significant aspects of what the accused stated. For instance, the accused said after receiving the Placencia Beach Club report through the diarist, the accused recollected a report from the previous evening from a Mr. James Leslie. The accused said he feared the individuals were the same persons who had threatened Mr. Leslie. However, the accused did not provide any reason he connected the 2 seemingly separate events. The report from Mr. Leslie, as told by the accused, was quite specific. No weapon was mentioned, and the persons reportedly said they would return, I presume, to Mr. Leslie. The report that evening did not come from Mr. Leslie. I wondered why the corporal and his team had not investigated the incident earlier that day, especially since Mr. Leslie said the persons were known to him. In any event, if this previous report was on Corporal's mind when he went to the beach club, it was faulty reasoning on his part. Additionally, although the accused spoke about this report in his unsworn statement, he had not mentioned it in his station interview. I question whether this previous report was operating on his mind at the scene. The accused said the report he received was of suspected persons, with one of the persons having what appeared to be a firearm. The defense witness, PC Irene Augustine, supported that this was she was told. So I accepted. Said the report was of 2 males and a female, with one person appearing to have a firearm. This may have predisposed the accused to think there was a possible firearm involved. I consider this, but the facts on the ground should have dispelled him of that notion. Also, this recounting of the report differs from what the accused said in his station interview. The accused continued that after arriving at the beach club and speaking to the security officer, the accused asked if any of the males had a firearm. This was because although Mr. Castillo, the security guard, mentioned a firearm to the diarist, he had not said this to the police upon their arrival. At this stage, Mr. Castillo says he believed so, and he led the police to where the person were last observed, close to the beach. Having visited the scene, the entire area is small, compact. The deck of the beach club is a stone's throw from the sea. I have to wonder, if Mr. Castillo intentionally mentioned a firearm to the diarist on his second call because the police had not arrived after his first call when he said nothing of a firearm. Mr. Castillo testified in court that he could not tell if the persons had anything in their hands. At the visit into the locus, he said that he saw nothing in the hands of any of the persons. When Mr. Castillo hid by the outdoor shower and saw the persons, he was no more than 20 feet from them. He would have seen the hands of 3 persons clearly. The accused continued that they saw nothing in their initial search, and as they were about to return to the beach club, 2 males came running towards them aggressively. I found the language of the accused here especially revealing. He said that upon noticing us, which gives me the impression that if the persons were indeed running aggressively, the aggression was not directed towards them. The accused said the male persons then rushed back, and they were followed by Miranda and the security guard behind one person. This would be Thomas Palacio and Papa and Augustine behind the other, the deceased. It is remarkable that the accused did not say here any of the other officers said police or stop, police, or even just stop. This differs from Crown witnesses who claim a stop command was given, which I have discussed earlier. It is also astounding that the accused, who was a superior officer, stood on the beach permitting a civilian to run after persons who he claims he thought possessed a firearm. He says he noticed Pop and one of the persons in a slight scuffle. None of the Crown witnesses support this. This is a critical portion of the statement which describes the moment leading up to the shooting and the actual shooting itself. I cannot accept this account from the accused. It does not agree with any other witness. Although I have discussed difficulties with some of the Crown witnesses, I do believe the general story they told. I do not believe there was any scuffle, slight or otherwise, and I do not believe the accused saw a shiny object in the hand of either Thomas or the deceased. I wonder why he did not use a flashlight to better see what was happening as he stood at distance from his colleagues chasing the deceased. The accused then says, I then turned away from the individuals that were running, removed my police-issued firearm, and fired a shot into the air. Then that would be 10 feet off the ground into the air. I do not believe the accused when he says he turned away from the deceased and the others as they ran and he fired his gun in the air. This would mean the accused thought the situation was serious enough that he was justified in discharging his weapon, but considered it prudent to turn away from the unfolding dangerous activity. The account from the accused would also mean the bullet he discharged traveled backwards and downwards and outwards or horizontally, 75 to 90 feet to strike the deceased in his back, all in 6 seconds. The time the accused says it took the deceased to collapse. Miss Lino said numerically, most standing persons shot by a firearm discharged in the air are hit in the upper region of their body, head, and shoulders. She did say it was possible to be hit in the back by a bullet fired in the air. But I am reminded that Miss Lina said it has so much power or kinetic energy behind the bullet still to allow it to fall from a great height at 90 feet. It is unlikely that it would fall that distance in the space of 90 feet. The distance between the deceased and the accused was between 75 to 90 feet. So it may have been even less than the 90 feet the expert testified about. Combining common sense and the expert's testimony, I do not believe the accused discharged his pistol in the air at all. I believe he shot towards the deceased and struck him in the back. The accused says he remained on the beach, but must have been both persons' fault. Yet he says he did not approach until PC Pop called him over. If his statement is to be believed, his conduct is and also inexcusable. He says when he reached the spot, he saw PC Pop with one of the individuals in his hands, whereupon the accused asked if the person was hurt, and Pop said he did not know. The accused said they rushed the injured person to the polyclinic. Thomas said the men stood over him and talked before moving the deceased and him to the mobile. They dropped him at the police station before going to the polyclinic. They did not rush the deceased to the clinic. I am aware that even concluding that the accused is not being truthful in what he has said to the court, I cannot convict him on that basis. Accused persons may fabricate defenses for reasons other than guilt. And she made reference to the case Bradhurst and the Queen. So it is not my disbelief in the denials of the accused that lead me to the verdict in this trial. It is my acceptance of the prosecution's evidence. As I consider the statement of the accused, I continue to direct myself that the accused has nothing to prove to this court. Even as I do not give his statement great weight, it does not mean that I may convict him as a consequence. It is the prosecution's evidence that must make me feel sure of the guilt of the accused. So I will refer to the prosecution's case, reviewing the testimony of the defense witness. So she looked at the defense witness, and the defense witness, they would call one Irene Augustine. The defense called PC Irene Augustine, who was a diarist at the Placencia police station on the evening of the incident. She was working at 4 p.m. to midnight shift, but worked until after 2 a.m. that morning because the station was short-staffed, she told the court. PC Irene received 2 calls from Mr. Castillo from the beach club and referred them to the accused, who was the senior officer on duty that night. She testified that Mr. Castillo never reported 5 suspicious males at the club, as the accused said in the station interview. The timing of the calls from Mr. Castillo to the police did not correspond with the times the doctor received the call from PC Augustine that someone was injured and being brought to the clinic. PC Irene Augustine says the clock on her computer and her phone were off by minutes. I was left to conclude that I could not completely rely on the accuracy of PC Irene Augustine, at least as it relates to the timing of the incident. Her evidence was not of much assistance in my overall deliberations. Final comments. In considering this matter, I could not help but be reminded that Belize is a state party to the Convention on the Rights of the Child. The convention was imported into our domestic legislation through the Families and Children Act. The state and its agents, which includes the Belize Police Department and its members, have the responsibility to protect, and respect the rights of all children in Belize, as set out in the CRC. Among these rights is the precious right to life. In this case, the deceased was a 14-year-old boy, a child in Belize, and as such was entitled to all of the rights of the CRC, including his right to life. The deceased was deprived of his right of his life, taken senselessly by a law enforcement officer whose sworn duty is to protect children. This case also brought to mind the constant cry for additional training of our police officers. Not all, but much of the testimony from the police witnesses in this trial illustrates the need for continued training in the basic tenets of policing and indeed the Constitution of Belize. Officers should understand that and be able to clearly articulate when the use of force is permissible, what excessive force means, when a warning shot is appropriate, if ever, and when and how a person may be lawfully detained. Finally, it is a positive initiative that the police department is currently developing a child interaction policy, which hopefully will result in less negative, violent, and other encounters between children. As a society, we must do all that we can do to act in the best interest of children in Belize. The verdict. Based on the foregoing analysis of the evidence and application of the law, I find the accused guilty of the crime of manslaughter. That is the verdict of this court. Sentencing will be set to a date agreed upon by the parties. So there you have it. There it is. The judgment as per Madam Justice Antoinette Moore. While a guilty verdict will not bring back the young life of Laddie Gillett, who was just beginning his life, at the beginning stage. A verdict of this nature, a well thought out judgment, a solid case by the prosecution, despite the defense position. Despite that, this case shows the importance of why training as it relates to protection of human rights is vital. Protect our children. Justice for Laddie. And with that, I end this recording. And I thank those of you who listened to it. And I made this for those of you who might not have the time and would prefer to just listen to get an appreciation of the police who went to court and lied on oath and make up stories and stretch the truth, whatever that truth is, so that you could see what happens in courtroom. This is more than what you would get on a news broadcast. So appreciate the fact that you have the judgment read to you. So if you don't want to read it, really and truly, you can listen to it. And with that, Get Legit LLC ends this broadcasting, and I thank you all. And rest in peace, Laddie Gillett. I'm happy that the family has some form of closure. I know a guilty verdict will not bring you back, but it's a step in the right direction to protecting the lives of our innocent children. Thank you.